Mode.
Welcome to the State Board of Election meeting. We have a quorum. Pardon me, it's May 4th, 2023. It's about 2:01. We have a quorum. So we will begin the meeting. I believe we have only 4 members. We have one resignation of Justin Williams, who was a good friend and a very good servant, but he is also serving on another board and could not serve on both. So he resigned this past week, and we don't have a replacement for him yet. We have 4 members here. 4 are required for any votes, so anything will have to be, of course, unanimous. So are there any additions to the agenda? I believe the only addition we have is we do have a speaker that has been approved, and that speaker would come in after the closed meeting, when we come into old business to discuss the process to appoint administrator of elections, we will have that speaker just prior to that discussion. So we will insert that just prior to A, under old business. So are there, next item on the agenda is the approval of updated minutes from February 23rd, 2023. I believe that has been disseminated. Are there any updates, deletions, or corrections to those minutes? Seeing none, the chair would accept a motion to approve as presented the minutes from February 23rd, 2023.
Second.
Moved and seconded. All those in favor signify by raising your hand. We have 4 in the affirmative. They have been approved. Now we move to the approval of the minutes from March 29th, 2023. They also have been disseminated. Are there any additions, deletions, or corrections to those minutes? Seeing none, the chair would accept a motion to accept the minute of March 29th, 2023 as presented.
So moved.
Is there a second to that motion?
Second.
Moved and seconded. All those in favor signify by raising your hand. I think we have background noise. I'm not sure where that's coming from. Okay, then we have the approval of minutes from the closed session on April 18th, 2023. Are there any additions, deletions, or corrections to the minutes for the closed meeting?
Mr. Chairman?
Yeah.
I think there was one change. Let me see if I can pull that up. I think something was misattributed that should have been attributed to Mr. Miller.
Okay.
I'm trying to pull those up. What link was that in? Sorry.
Yeah.
Here we go. Okay, closed meeting minutes of April 18, correct?
Yes.
One, two, three. Fourth paragraph. Mr. Velp expressed the need to find a qualified individual to ensure an overlap of time. I thought that was Mr. Miller. Sab, do you remember that being you?
I don't remember one way or the other.
Okay. I mean, it's not all that material. It just struck me as incorrect. But if you don't remember it, then we'll give it to Bill.
Yeah, I remember feeling that. I'm not sure if I said it or not.
Okay. All right.
Change that.
Yeah. So seeing that there's no clear definitive change, is there a motion to accept the minutes as presented?
So moved.
Is there a second?
Okay.
Moved and seconded. All those in favor signify by raising your hand. It is approved. We move on to the administrator's report, and I would just remind whoever's giving their report as part of the administrator's report that if they would just give the highlights, anything that you would like to point out that we should know here on the public record, because these will become part of that record anyway.
Good afternoon, Nick Thompson, Deputy Administrator. Just wanted to call out a couple of federal board meetings that we've summarized in the Administrator's report, and also the fact that for the first time, the federal government is giving us, the federal government under the Department of Homeland Security is giving us some grant funds through the Maryland Department of Emergency Management. So we've been working with the local boards to put together projects that they can apply for, as well as some projects at our office. So the application is due. We don't submit it. We actually provide the information to the Department of Emergency Management. It's due May 14th. Well, this says 18th, but I've seen the 14th. So it's due this month. And hopefully we'll hear in the summer whether we got that money. So it's well needed money to help usually make some physical improvements to our offices and facilities that governments don't like to do. And so with that, I'll turn it over to Election Reform and Management for the highlights of there.
Good afternoon, everyone. So the election judge, the election reform and management is of course been busy. We are gearing up for 2024. Since that new legislation for HB 1200 was passed, we have to figure out some solutions for offering bonuses for returning judges. So we're going to share that information by the end of the month. Social media, we have procured a new software solution for posting concurrently across all of our platforms. It's called Social Pilot. We are working towards a solution for a usability review for our new poll book and the sample ballot template design with the Center of Civic Design. And we're also looking to do some work with them on some forms. So that's pretty much what we have going on. If you have any other questions, I'll be happy to answer them.
Mr. Chairman? Yeah, I have a question. It's just I find it a little vague. So I'm looking within the Election Reform and Management section of the Administrator's Report, 2023 Maryland General Assembly follow-up highlights. And second sentence, SBE staff are reviewing the final legislation to determine the impact to various computer systems. What does that mean? Are we talking about the computer systems that are used in the elections themselves, or computer systems used internally at SBE? Could I get an example of what that means? I'm just curious.
Jen, do you want to take that?
This is Donna. Hi, I wrote that sentence. It means what changes have to be made to MD voters to allow payment for the extra payment for election judges. It's the internal working systems.
Yeah, Donna, this is Jen McLaughlin, everyone with the staff as well. I would add that there's a ballot processing bill, HB 535, SB 379, that requires us to notify voters when they receive their mail-in ballots back under certain circumstances, under certain timeframes. So we're just, it's just changing minor things in our system so that that information is getting out faster to voters. Donna mentioned the election judge compensation bill, HB 1200, requires some changes into our internal and voter system and things like that. But I think what you're asking is it an internal or an external facing thing? I don't believe it affects. I don't think a lot of things affect sort of the scanning ballots, auditing ballots, that sort of thing. It's more sort of processing information, sharing information more clearly and more transparently.
Okay, thank you. I appreciate that clarification.
Thank you very much. Any other questions from the board? Great. Moving on to voter registration.
Thank you, Bill. Just wanted to highlight just a couple things today. We did have our release of 9.1 in MD voters at the end of March, well within our 9.2 development at this point as well. And then in April, had a very successful test of our backup data center that we would use in the case of any emergency situations. So, late for me today, but thank you very much.
Great. Any questions about voter registration? Seeing none, who would be going next?
That would be me. Just wanted to, the 2024 election cycles, open for candidate filings. We have had 10 candidates file so far. We're still continuing on working with Baltimore City and their legal and the finance departments for the public financing and making sure that their program is up and running for the 24 election, and people can start basically filing, new political committees for public financing there. And then I just gave our enforcement actions as well. And I guess I'll turn it over to the poll book team then. If there's no.
Any questions for Jared on the campaign, candidacy and campaign finance division? Okay.
The poll book software continues to be configured and developed according to the schedule. And to prepare the Microsoft tablets that will be receiving that software, the vendors, the poll book vendors that we have actually arrived here in Maryland, a team of them, and they are now setting up the 9,000 poll books that we have in our warehouse with the proper versions of Microsoft Windows and an initial version of the ePoll tab application. That is underway. So I was just up there today, and a very busy place right now. And then also, now that we're getting kind of near the end here, well, not totally near the end, but we formed a subcommittee with the LBEs to kind of discuss the poll books, to discuss the screens, to talk about what sort of technology, working with the LBEs, get feedback from them on what it might mean for them. And we've got some really good information from the subcommittee. We continue to get good information. We're meeting weekly, and we've had them up to the warehouse actually to show them what's going on up there so they can see that process, which then also gives them a better idea of the type of work they may have to do, whenever the poll books get deployed. So we feel that effort is bearing lots of fruit already. Other than that, everything is going according to schedule.
Great.
Any questions?
Questions from the board about electronic poll books? Move on to the project management office.
Good afternoon, board members. My name is Keith Ross, and you have before you the status of the activity, some of the activities of the project management office, and open to any questions that you may have.
Any questions based on the report? All right, move on to information security update.
So once a quarter, we provide you with an information security update, which we have done there. Patrick, who we introduced at the March meeting, is here as well. Sort of status quo, we're continuing to monitor and protect our systems and engage in assessments as appropriate. And we're here to answer any questions you have. If they can't be answered in open session, then we could do that in closed session.
Great. Any board members have any questions about information security? Some of which could only be answered in closed session. Seeing none, I think that concludes our administrator's report, correct? Are there any general questions about the administrator's report before I move on? Seeing none, we move on to the Assistant Attorney General's report.
Afternoon, members of the board. Still only 2 cases on the report. No change in the second one, the Johnson case. As for the first case, the Gibson case, the federal district court did in fact dismiss the case and denied the plaintiff's Rule 59E motion to amend that dismissal. That completed it in the district court. The case is now finished in the district court. A day after the denial, the plaintiffs appealed the case to the Fourth Circuit. It is currently pending in the Fourth Circuit. Actually, yesterday, I wrote this report about 3 days ago. Yesterday, the Fourth Circuit issued its briefing notice. Plaintiff's brief will be due to the Fourth Circuit by June 12th. Appellee's brief, our side of the case, will be due by July 12th. The Fourth Circuit has a local rule that when there are multiple defendants or multiple appellees on one side of the case, they usually only want to see one brief from all the appellees. And right now, the plan is for the Office of the Attorney General to write a brief on behalf of the State Board of Elections that the other appellees in the case will then sign on to.
Okay. Great. Any questions? I am just profoundly shocked at how short this report is. So
You're doing a very good job of not getting sued.
that's as we endeavor to do. So I'm sure, I think I've said that before, that you've done a great job, and Andrea, who was before you, did a fantastic job as well spinning that out. So thank you for your hard work with that. So, any other questions for the Assistant Attorney General? Seeing none, let's move on to the approval of proposed regulations. And there are a number.
Yeah, so we're going to tag team them. The list in the agenda has you have 2 documents or 3 documents that relate to that list. There's one document and a memo from Jared on the campaign finance. And then there's a document of proposed changes that Melissa and I will tag team depending on who wrote them. I will say for the regulations that Melissa and I are going to talk about, we have shared with the Maryland Association of Election Officials, and they provided their feedback, and we've incorporated that where appropriate. Jared, do you want to go first with yours, and then Melissa and I will follow behind you?
Sure. Sorry, just had to get it off on me. Right. So my 2 here are very simple. So they are for approval 33-13-10-05 and 33-13-06. So the first one is the 33-13-10-05. It's about a contribution conversion. This proposed regulation codifies our existing policy on reporting contributions. It prevents basically the circumvention of contribution limits and surplus fund requirements with individuals basically trying to amend contributions into loans after they have been already reported as contributions because of surplus funds towards the end of the campaign. We have, conferred with the Office of the State Prosecutor, and they're in support of this codification as well. This has always been the policy of the State Board, so this is just now making it into regs. The other one, 33-13-13-06, is about administrative accounts and permissible uses. This proposed reg allows for administrative account funds to be used for fundraising activities exclusively for the administrative account. So currently, the regulations do not allow for such a type of disbursement of administrative funds for fundraising activities. But basically, a central committee and a legislative party caucus committee would have to then make expenditures from their electoral accounts for these activities, but you cannot use electoral funds for administrative purposes. That's against the law. So this is was basically an oversight initially, and this make sure that that a central committee or a legislative party caucus committee can use administrative funds to fundraise for that account if it's exclusively for that account. So this is just making sure that it corrects that situation. So those two for your approval, and I'll welcome any questions.
Are there any questions? This is just two pieces of proposed changes. And let me say, these would be the first round. These would not be final regulations. We're voting on something that would go out for public comment, and that period would come back to this board to vote on for final regulations. There's a number of them. We've had them in advance to review. We're dealing right now just with 33.13.10. 05 and 33.13.13.06. These are the two Jared just proposed. So are there any questions on those two?
Mr. Chairman, I have a question.
Yes.
Jared, on the contribution conversion proposed rule, the use of the word alters, why was that word chosen rather than converts? May not be amended in a way that alters a reported contribution, as opposed to may not be amended in a way that converts a reported contribution.
It was just one of those words I worked with Dan from the Attorney General's office on, I guess, because it alters the original filing that has been published out in the public. So rather than converts it, because for anybody to look at it, it would be the filing itself, the paperwork has been changed. So I think that's why we went with that word rather than converts.
Okay, that makes sense. Thank you.
You're welcome.
Great question. Thank you. Any other questions? Again, just about .10.05 and .13.06. If there are no questions, the chair would accept a motion to accept as presented 33.13.10.05 and 33.13.13.06 on campaign finance reform COMAR changes.
So moved.
Is there a second?
Second.
Moved and seconded. All those in favor signify by raising your hand. It's unanimous.
Thank you.
Next.
I think I'm going to start off the next round, and I will first be doing 33.02.03.01 through 05. They all effectuate the same change, and that is to allow the local boards of elections to use electronic versions of training materials for election judges. So the manual, online training, things of that nature. And then it also alters the compensation for election judges to reflect House Bill 1200 that we referenced earlier, which was just passed in the most recent session.
So this would be 33.02.03.01 through 05. Is that right?
Yeah.
And we do, the board again has had them in advance. Are there any questions on those proposed regulation changes? Again, this is 33.02.03.01.02.03 all the way through 05. Any questions? If there are no questions, the chair would entertain a motion to accept those proposed changes as presented for 33.02.03.01 through .05.
So moved.
Is there a second?
Second.
Okay. All those in favor signify by raising your hand. It is unanimous. What's next?
Thank you.
I'll take the next two so we can do them out, whether you want to do them together or one at a time. So the next section is 33.11.01.04. So we're talking about mail-in ballots and the ballot drop boxes. So up until now, we have applied the same no electioneering zone area for ballot boxes as we did for voting locations. So the no electioneering zone was 100 feet And that's what we used in 2020 and 2022. It came to our attention in 2022 that there were some places where if the ballot box was placed at the outer edge of the no electioneering zone for the polling place, that the no electioneering zone almost became twice as large. And so we wanted to come up with an approach to balance the interests of the voters and the interests of the candidates. And so this proposes, in most cases, a 50-foot no electioneering zone on the exception is if the ballot box is located within the 100-foot margin, the 100-foot zone of a voting location. And if that's the case, then there's not an additional no electioneering zone. The box is already in one, and the line would just be that of the voting location. So trying to balance those two. And also, before the last election, Dan was super helpful in helping us identify what behavior was okay in a no electioneering zone and what behavior is not okay in that electioneering zone for ballot boxes. And so what is outlined in E and F in that new section or that new subsection are those behaviors that are acceptable and what's not. Where can you record? Can a group of people be inside the no electioneering zone? Can one person? And so this is codifying the advice that Dan gave to us in 2022 as we were dealing with inquiries and voters' concerns about their safety in and around those ballot boxes.
Okay. And that is just what, as it pertains to 33.11.01.04, is that correct?
Yes.
Okay. Are there any questions about that report?
Would you like me to do the next one, or did you want to do those individually?
No, I'm just reading through one thing. I
Oh,
have
sorry.
Okay, so practically the box, let's say the box is outside of an electioneering zone. 50 feet around that box is a no electioneering zone. Let's say that box is at a school, it's on the other side of the school, within 50 feet, no one is electioneering. It's also saying, basically this is saying that if you can also not, if you're dropping off, would this have the effect to say if you're pulling up to a drop box to drop it off, that you could not have a firearm in your car or on your person, even if you had a concealed carry permit?
Dan, can I defer to you on that?
Absolutely. And a more involved discussion about this, if the court wants to hear legal advice on the Second Amendment implications here, should probably take place in closed session. But the answer directly to your question, Mr. Chairman, is yes, that a person carrying a weapon to drop off a ballot would not be allowed to possess or carry that weapon within 50 feet of the drop box.
I got problems with that. And not because I think people should be carrying firearms to go up and vote. I'm thinking somebody pulls up, I'm thinking like Glen Burnie High School, which is, not far from my house here. And I've seen their drop box. There's a parking lot right next to it. Somebody happens to have their firearm with them legally. It's in the car. They pull up. They can pull up very close to that drop box because they're voting. They hop out of their car and they put in the thing. They happen to have the firearm in their car, and they have actually committed now a violation of COMAR without even thinking about it. It's not even on their person, it's in their vehicle. But they're possessing it when they're in their vehicle and they're inside the 50 feet. So I'm not sure how to reconcile that in my head right now. I don't know how any other of the board members feel about that.
I think your point's well taken, Mr. Chairman. You would have an inadvertent violation of the law while you're otherwise legally carrying or legally possessing we're not getting into whether somebody's legally possessing or not. The presumption would be legal possession. And would inadvertently violate this provision simply by being able to pull up to a particular area, get out and vote through the ballot box. So I think it's worthy of kind of either talking about it in closed session with council or having staff and council go back and revisit that particular piece of this so that it can be, so that law-abiding citizens who are in possession of firearms don't run afoul of this.
Yeah, I agree. I don't know. I mean, I'd like to hear, would you all like to just have this discussion in closed session? I can tell that Dan would like not to, I'm just looking at you, Dan, and I'm assuming you have some things to say, but you cannot say them in open session. Would that be correct?
Yeah, I can brief the board on sort of the legal background for why this was written this way. Any discussion you want to have about its merits, though, has to happen in an open meeting.
Right. Okay. I would like to defer 33.11.01.04 if we could have that discussion in closed session and then either be able to return to it if for some reason everybody's okay with it, or return to it again after our closed session and push this back for reconsideration. Is the board okay with that? Yeah. Michael, your thoughts?
No, I defer to Dan, and I'd like to wait and hear what he has to say in closed session.
Okay, great. So we're going to talk about, does my script to go to closed session, Nikki, include advice from counsel?
Yes.
Okay, great. So that'll be covered under our closed session. Thank you, everybody. We'll do that there. So we're deferring 33.11.01.04.
Great.
What's the next one?
So the next one is 33.12.02.01. So this is about recounts. And we currently have 4 recount options. The proposed change limits the number of recount options a candidate can request to 1. This potentially was an issue. It was an issue. It was a question in the 2022 primary where there were lots of close races. And we had one candidate in particular who asked for all 4 recount options. And the local board was able to talk the candidate through it so that she ended up not asking for any. But the point was still there that somebody could ask for all 4. It could it could increase the amount of time to prepare for the recount, conduct the recount, delay the results. And so wanted to respond to what happened in 2022 with this change that limits a candidate to selecting just one of the 4 recount options.
Great.
The reality is that most candidates only pick one, and they pick the most comprehensive one. But to the extent that there are other options, this candidate really wanted all 4, which was somewhat redundant to have all 4 done.
Okay. Comments from the board or question? Seeing none, the chair would entertain a motion to accept as written 33.12.02.01.
So moved.
Is there a second?
Second.
All those in favor signify by raising your hand. It's unanimous. We move on to the next.
I think I have kind of 2 topic areas. So I'll start with 33.16.02.01.
Okay.
Is actually just kind of a little bit of cleanup from the February 2023 meeting, where we repealed a regulation that provided for a specific application for provisional ballot for same-day registration. We're no longer going to be using those going forward, and this regulation references that repealed regulation. And so we just need to remove that reference.
Great. Any questions from the board about 33.16.02.01? Seeing none, would someone like to make a motion to accept as presented?
So moved.
Is there a second?
Second.
All those in favor signify by raising your hand. It passes as presented.
And then the next topic area is early voting. So that's going to be 3317.04.06, 3317.05.03, 33.17.07.01. And they all have the same kind of cumulative effect. There was, up until now, a early voting supplement manual for election judges that's become kind of unnecessary and a bit redundant. So as we've kind of expanded what's available for election day and early voting. So that supplement is no longer going to be required. All of that material will be incorporated into the normal election judge materials. And so all of the references to the supplement are being removed. And it also puts the election judge training program for early voting kind of on par with the election day program and reflects the changes from House Bill 1200.
Okay. Great. Are there any questions from the board on these procedural changes for 33.17.04.06, 33.17.05.03, 33.17.07.01? Any questions? Seeing none, is there a motion to accept those three as presented?
So moved. So moved. Second.
Moved and seconded. All those in favor signify by raising your hand. It passes. Next.
Okay, so the next two are about same-day registration. So sub 33190101, which is about, so this is about when same-day registration and address changes are available during early voting. So when the special election is conducted by mail, there must be early voting. That's a requirement of state law. And so this regulation fixes that. What happened in the February regulations, we proposed some changes, and the Department of Legislative Services pointed out this conflict that we had. So we are not moving forward with the regs on this section that you approved in February. We withdrew them to fix it, and now this is our fix. So it's making clear that if there is a special election conducted by mail, there must be early voting and there must be same-day registration and address change. So this is a cleanup from something we did in February that didn't go anywhere. So there's not like we have to undo anything else. We just withdrew it and are now reproposing this to eliminate the conflict that we had in essence created in February. So my apologies for that. So that is this one. The 33190201, again, it's about same-day registration and the public notice requirement. We had always, before each election, sent out postcards to voters who appear eligible but aren't registered, and letting them know that they had this opportunity to register and vote during early voting and on election day. When we had a special election, they just happened fast, and we don't have the time to generate that mailing. There's just not enough time to procure it, get the data, get it produced and printed. And so what this change is doing is it's giving us a little bit more flexibility as to how we provide that notice. Our plan for regularly scheduled elections will to always be to do the postcard. There's no practical change to this, but we just can't do that postcard with a special election. There's just not enough time. And so we will use other ways to notify voters who are eligible for that special election about this opportunity, or about individuals who aren't registered to vote about this opportunity. So this change just gives us some flexibility for special elections, but it won't change what we plan to do for every regularly scheduled election.
Thank you. Are there any questions about those two changes to Omar? Seeing none, the chair would entertain a motion to accept as presented 33.19.01.01 and 33.19.02.01.
So moved.
For a second.
Second.
Moved and seconded. All those in favor signify by raising your hand. Unanimous. I think we have one more.
Thank you. So this one is subtitle 21, so 332103. This is about special elections by mail. At the February meeting, we proposed changes to the section to fix the postage disconnect. And the Department of Legislative Services noted that the free postage applies to if it's a vote by mail ballot sent by mail. If it's sent electronically, there is no free postage. So this proposed change clarifies that the free postage only applies to ballots delivered by mail. And we appreciate them pointing that out. And that's the change to 33210302.
Okay, and that's both of them that would include 03 as well.
I'm sorry, can you ask the question again?
So it's 33.21.03.02 through 03, is that right?
I don't vote in 03.
Okay, so on our agenda, it says through .03, so I guess.
Oh, it's just 02. Yeah.
Just 02, so yeah, I was looking for that. Okay, no problem. So are there any questions about that change? And it's strictly to 33.21.03.02. Seeing none, the chair would entertain a motion to accept as presented 33.21.03.02 change to Comar.
So moved.
The second?
Second.
Moved and seconded. All those in favor signify by raising your hand. Okay, I believe now we move to final regulations and campaign finance. I would imagine this is Jared.
Yep, that's me. Thank you. And let's see. So I have it here. So basically, in front of you is from the October board meeting. We had the proposed regulations. We had one public comment received, and that was only in regards to the proposed regulation, which is 33.13.10.04C. And it was talking about the firewall requirements to prevent strategic campaign information from being passed between candidates and outside spenders. The current proposed regulation was the codification of the issuance of a declaratory ruling by the state board in 2017, and has been basically in effect since then. So at this point here, I recommend that we just proceed with the adoption of the proposed regulations as drafted, since that's our policy and has been in effect since 2017 and seems to be working well in the state. We can always revisit if strengthening is required later on. But with that, I just move that the board move to finalize these regulations as proposed.
And so they've already been through their public comment.
Yes, they've already been gone out for comment. They've been published at the Maryland Register. The comment period closed on April 10th, and we just had that one public comment on that one specific issue. Outside of that, all the other regulations did not receive any public comments. And I have included the original memo too, just in case there was any questions about what they were, with the codifications or the rationale behind the regs.
Okay. Are there any questions from the board about these final regulations having to do with 33.13 for campaign finance that were from the October 22 meeting and have now been through public comment? Seeing none, the chair would entertain a motion to approve the final regulations as presented and voted on from October 2022 and 33.13 and
33.18 as well too. There's the violations as well.
33, including 30.18.
So moved.
Okay, is there a second?
Second.
Moved and seconded. All those in favor signify by raising your hand. Has been approved. We move to the approval of the delegation of duties.
Thank you. So you should have two documents in your meeting materials on delegation of duties. One is a document that lists all of the duties and shows what's been delegated up to now and has the proposed ones in. And then what I did is I just took them and put them in a other document so it'd be easier to follow along, hopefully. So the document I think that might be easiest to go through is the document that's a 2-page document, not the one that's an 8-page document. So in the 2-page document, the rows shaded green represent new duties. So these are duties that have been in the last couple years. They resulted from legislative changes. So those are the green ones, just tried to make them easier to track. And then you'll notice that there are some footnotes. There's a footnote, a key guide in the footnotes that shows which ones, if delegated, would require public notice under a provision of the election law, and which ones with a hashtag or the pound sign would require being reported to the state board no later than the next meeting. So I think maybe the 2-page document is easier to have handy. It also shows at the bottom under the table shows other changes made to the full document under the duties of the state administrator section, which new duties were added as a result of legislation, and one that was previously omitted. And then the forms, guidelines, and procedures and regulations table also has new duties that have been added or taken out.
Thank you so much, Nikki. There's a lot of work here. I appreciate it. The board hasn't had these already in their hands. I'd like to use chair's prerogative and look at this by exception. So rather than going over each one, I would like to open this up to if any board member has any individual duty that they would like to discuss about whether it should be delegated or not, that we would do that by exception and then vote on them as a whole. These are ones that I've already spent a good deal of time going over them as well with the
Mr. Chairman,
please.
My question is actually broader in scope, just to understand, and perhaps anybody from the public who is sitting in our meeting. What is the difference? To whom would something be delegated is the question.
So there are, I'm going to give it to you in a nutshell, and probably Nikki can answer it in more specifics, but the things in law are given to the SBE, this board, to administrate. And then we delegate those responsibilities to the election administrator, the state administrator. And then the administrator does those duties through their staff. So we already have a substantial amount of things on a document that has been delegated. Those are voted on typically yearly or once every 4 years as the board changes, or once every 2 years or 4 years. Those changes are typically driven often by legislation and sometimes by practical changes of who does what functions. They are also able to be pulled back should the board see something that they would prefer to pull back and administrate themselves. They could undelegate that duty at any time. Does that answer your question? Or Nikki, would you like to add to that? Is there anything that I didn't clearly present?
No, I think that was an excellent explanation. I guess I would like to explain something that I missed in talking about it. There are a couple duties on this document that we have a recommendation not to delegate. I just wanted, so when if we get to the point of a motion, it's not delegating everything in here. There are 3 that we are saying we think that you should keep those. It's the others that we recommend delegating.
Right. Okay. So you'll notice that on your form, you'll say three, that this has been through a change, one form or another, and we are recommending that the board not delegate those three. The other one recommended for delegation.
Okay. That was very helpful. It confirmed and clarified some thoughts on that. So I do have a particular question about one of the provisions that is being a new duty being recommended as a do not delegate.
Okay.
Specifically, election law section 13-249 G4.
Yes.
Issue report on coordinated expenditure finding. I assume that's funding. Coordinated expenditure finding or funding and impose civil penalty. So the first question is, one, is that correctly identified as finding rather than funding? Just a question. And then secondly, why has that one been recommended to not be delegated to the election administrator and thus corollary to staff as necessary?
I guess I can answer that one, Nikki, if you want.
Yes, please. Thank you.
Please go.
Yeah. So this was the state administrator or the designee has to conduct an investigation when trying to find whether coordinated, if there's coordination between an outside spender and a candidate. So we're already conducting the investigation. The state board then here's our evidence. It's more of an administrative hearing at that point there where we put it on, we can subpoena witnesses and they put on their defense as well. The state board then issues a public report on its finding and then can impose a civil penalty based upon the report that we would give the state board. But we couldn't be basically judge and jury for that one there. So it's kind of, we're doing the investigation. We present evidence to the 5 member board, and then the board would then make a determination. It's more of an administrative hearing process. So that's why it could not be delegated.
Okay, that makes sense. Thank you, Jared. Appreciate that.
You're welcome.
Great question. Thank you so much, Scott. Any other questions from any board members?
Oh, and just again, back on the one you just talked about, Jared. So that the text of that is correct, that it's a report on coordinated expenditure finding.
Yes,
You're making a finding and you're making a recommendation.
Right, exactly.
So the board would be acting upon that you've made a finding about a coordinated expenditure.
Correct.
Okay, got it. Thank
Yes.
you.
Thank you for that clarifying question, Sky. Any other questions from the board about any of the delegate or do not delegate? Seeing none, the chair would entertain a motion to accept a proposal for delegation and non-delegation. In specific, there are 3 functions presented today, do not delegate, and all the rest are presented to delegate those functions to the state administrator. Would accept the motion to that effect.
So move.
Is there a second?
Second.
All those in favor signify by raising your hand. It is complete. Thank you very much. And we move to approval of a confidentiality request. Who is doing that?
Sorry, I put myself on mute. There's one confidentiality request in front of you for your approval, and it is for a member of the state judiciary and has been verified.
Okay, great. Any questions from the board on that? Pretty clear cut. Is there a motion to accept the confidentiality request as presented?
So moved.
As moved and seconded, we'll accept Mr. Miller's as a second. All those in favor signify by raising your hand. Confidentiality request is approved. Now we have the approval of waiver requests.
Yes, exactly. So in front of you, there are 21 waiver requests with the recommendations for your approval. I submit them as one package. If there's any questions, I'd be happy to answer them. I also have included, there's no action needed on the denials. There are 6 denials in there just for basically for your edification there. And so far total, we have collected over $47,000 in late fees. And for the month of March, we collected a little bit under $19,000.
So we have 21 waiver requests that the board has to vote on. Does the board have any question on those 21 waiver requests? Seeing none, did somebody say they had a question? Okay, seeing none, the chair would entertain a motion to accept the 21 waiver requests as presented.
So moved.
Is there a second? Moved and seconded. All those in favor signify by raising your hand. So they are approved. Thank you very much, Jared.
Yes.
So now we
have Title 14 waivers now too.
Oh, I'm sorry. We have.
Yep.
Normally they're listed twice on the agenda.
Exactly. Yes.
I'm sorry.
That's okay. We have 4 Title 14 waiver requests. These were basically first-time filers with that employed a lobbyist, and Ethics is the enforcement agency on those late fees, and they have come back with and saying that they're not pursuing any enforcement actions against them, being the first-time filers. So therefore, I present to them for you for waiver of their first-time offense on this one.
Great. How many are there? I didn't bring that up.
4 total.
4. So are there any questions from the board on those 4 waiver requests for Title 14, right?
Yes. Title 14.
Questions on to approve the 4 requests as presented for Title 14.
So moved.
Is there a second?
Second.
Moved and seconded. All those in favor signify by raising your hand. Okay, great. So they are approved.
Thank you.
Is there more?
No, that's it. I'm done.
Thank you. So if I'm understanding this correct, we did not, I just want to clarify before I move to closed session. Does any board member feel a need to discuss anything about that came out of the administrator's report about network or public security? Seeing that not as a reason, I will not list that as a reason in our closed meeting agenda here. Let me say that we're going to move into closed meeting. I'm not sure exactly how long this is going to take. It's going to be advice from counsel. We will be coming back into this session. Once we do, we will move directly to old business. I believe we have a speaker that will speak and address directly to the issue at hand, which is a discussion of the process to appoint a new administrator of elections. So that is coming. We're going in to closed session first, but we will return. And I will say now that the board will now consider whether to meet in closed session to consult with counsel to obtain legal advice as permitted by Section 3-305, subsection B and 7 of the general provisions article. Meeting in closed session would allow the members of the board to seek and obtain legal advice with board counsel without the waiver of attorney-client privilege. May I have a motion to meet in closed session?
So moved.
Is there a second?
Second.
Moved and seconded. All those in favor signify by raising your hand. Great. The motion having passed, the board will meet in closed session in accordance with exemption B7 of section 3-305 of the Open Meetings Act. So board members, let's say we will meet in about 5 minutes at 3:07. Let's say 3:07 in closed meeting, and then we will be back as soon as that closed meeting is over.
Hey, live.
Great. Well, thank you for your patience in our leaving for our closed meeting. I would like to just go back to one item where we're discussing 33.11.01.04 and go back to that for a moment. I'm going to let any board members that have any statements to be able to make. I believe after receiving counsel and there's a request from the board that they would ask that we potentially, and I'm happy to have, by the way, any board member be fully heard on all of their thoughts, but I believe what we were looking for is for the board to consider approving, I'm looking for my document, there's so many documents today, here we are, removing item 1 for now and being able to come back and address that at a later time. So under F, other activities, number 1 would be eliminated. And I might have another solution for that as it's popped into my head. But we would keep number 2 and number 3 of F. I want to throw out that maybe the board would consider, except as noted in F2 of this regulation, an individual shall not brandish a firearm within the electioneering boundary set forth. We did not discuss that as a legal possibility, but I think that if I understood the will of the board in our last discussions, it was that there would not be potentially enough votes due to some inadvertent situations, especially as it deals with drop boxes. But certainly we can probably have the discussion around no one should be brandishing a weapon anywhere to intimidate someone. Would someone like to propose an amendment to what has been given, either to eliminate altogether number 1 under, let me get back to it here, under other activities F, or to amend it to say just brandish and remove possess and carry? Would someone like to propose something there?
Is this open for discussion? Okay. The brandishing leads to a direct threat. I understand that, but with regards to the conceal, is the intent of threat, potential threat. And in the free exercise of my right to vote should be void of any threat, potential or direct. So I'm a little hesitant on the amendment with regards to brandish.
Okay. So just so I can ask to make sure, you would rather at this time just eliminate number 1 and pass the rest of the amendment, the rest of the motion, and come back and deal with number 1 at a later time? Would that be more your thinking?
I'm still thinking about that.
Okay.
Following discussion.
I'll come back to you and let you speak on that if you'd like. I mean, we haven't worked together that long yet, Michael, and you'll find I want to make sure everyone is heard. I want to make sure everyone is fully heard. Everybody has the same rights here to be heard completely before anyone would.
No, I totally feel that.
Okay. Anyone else, either Sky or Seb, would you like to speak into either proposing an amendment of just eliminating number 1 so that it could potentially pass today, or a friendly or an amendment removing possess and carry at this time? Again, happy to go back and readdress it. Do you have any into that, Seb or Sky?
Mr. Chairman, I'll weigh in. I think under the circumstances, I would like to table consideration of section 1 or part 1 under other activities. It may also require delay well, it may not impact subpart 2. I am fine with 110104 F if we take out section 1 at this time and could take it up after a more discussion, including more consultation with legal counsel. As not saying anything that isn't already publicly in the Daily Record and other newspapers. The SB 1, the gun control legislation that was passed, once it is signed by the governor and becomes law, it will be challenged. I do not know if any of the piece of the legislation would be, or would that the polling place aspect of it would be subject to challenge, and even if subject to challenge, whether it would hold up. But there's still potentially some finality, I think, to the law that we are acting from, I believe, to deal with this particular section, other activities, part 1. So that's just my broad concern. And as I understand it, the next election in which ballot boxes would be deployed is sometime in 2024. Am I correct about that? Is that accurate? Okay. So, and fully understanding that it makes no difference how long out we might be from an election. A lot of things have to happen, and we don't want to push this longer than it needs to be. But there seems to be time to deal with it. And I am concerned about the law of unintended consequences that, or the inadvertent violation of the law by a law-abiding citizen, in terms of how it's currently worded. And I understand and I respect Mr. Summers' comments about that limiting the language to brandishing may not quite hit the mark in terms of concerns that could be raised by citizens who are exercising their right to vote and in some way real or perceived threats or intimidation. So obviously there's a tension. I'm not going to call it a balance here. It's actually more of a tension of two fundamental rights. And it seems that it still needs to be sorted out a little bit to get the language just right in light of the extension of the polling place into the ballot box, the area surrounding the ballot drop boxes, just to be clear in the terminology. So those are my thoughts. I do not think that an amendment to this today to leave only brandishing or only brandish would be something that I would vote for.
Yeah. Let me respectfully withdraw that comment. After hearing Michael's comments on it, which I completely respect, I agree. I think that either we table the whole thing or we just, in the essence of getting the rest of the regulation done, for now, we take out number 1 for now until we can get something that would be worded in a way, and I can explain more. Seb, did you have anything to comment?
Yeah, I'm glad you withdrew the suggestion of brandishing. I'm not a criminal lawyer, but I have a feeling that that's assault with a deadly weapon, which is probably also criminal. So we haven't added much if we just say, don't be a criminal when you go to the ballot box.
Mm-hmm.
But I think our the reason we're seeing some tension is the case of somebody who inadvertently is legally possessing a firearm 51 feet away from a ballot box, a drop box. And when they cross that line, they become someone who's doing something illegal, even if there's no even knowledge of what they're doing. That it's in the car or whatever. That's kind of the reason we're having some pause about this. So all things considered, I would suggest approving the reg minus number 1.
Michael, is that something that you could agree to?
In light of Seb's and Sky's, explanation, the unintended consequences of all citizens, being met by all citizens, I think it's worthy to consider leaving, that aside, because, all citizens have the right to vote, and all citizens have the right to bear arms responsibly. So I think we don't want to institute or put in the regulations any unintended. I think there were recommendations to post signage. I think that's around the drop boxes, similar to what is in place with regards to the polling place. I like the giving of notice but I am open to tabling that for further discussion pursuant to, what has been stated with regards to unintended consequences.
Right. Okay, great. And as we push back with the staff to rethink about this, let me say one thing that I had brought up in a legal question that I think I can bring out here. And I use an example in Baltimore City. I'm involved in a church that's at Clinton and Eastern. There's a drop box that exists several blocks away. If you were not voting and were just walking down the sidewalk, legally carrying concealed because you were a legal carrier, you would violate these proposed regulations by coming within 50 feet of the drop box, even though you're not even voting. You're going by on the sidewalk. So we have to have a way to protect everybody. I think we're all in full agreement that we would do anything. We want to do lots to make sure that voters are not intimidated. We just don't want to bruise other people's rights when they don't know. So the chair would accept a motion to approve 11-01-04 with everything except for number 1 under F. 04F, number 1 would be removed. So 2 and 3 would remain and become 1 and 2. And number one. So is there a motion to
So moved.
That's moved and seconded. We'll give Michael the motion and Sev the second, right?
I think Michael had a question.
I'm sorry.
I had a question, not a motion.
Please, I'm so sorry.
I apologize. I need to be quicker. With the striking of 1 at this moment, can we have language put in the record that it will be brought up in the next meeting for vote?
The whole thing, or do you mean what we're going to do about that? So what you're asking is this: you're directing the staff to think about a way to meet the needs that they've heard today and come back with a different proposal in the next meeting. Is that what you're asking?
For vote, yes.
So in that effect, let me ask Nikki and Linda: would we be better off tabling the whole thing and having the staff come back with some different language in the next meeting and deal with it all in once, rather than piecemealing this meeting to meeting?
Probably, just because if we move forward with part of it, we can't actually amend it until it's finally adopted. So it might be cleaner to just sit on table 331104 in its entirety and then revisit it at the next meeting.
Okay. Is that okay by you, Michael?
Yeah.
Is that okay by you, Sky? Sev? Okay, so this is effectively tabled. There's obviously not votes here. We're not going to vote on it. It is tabled, something we can talk about in the next meeting and see if we can find some kind of ground that protects citizens and voters. Not that voters aren't citizens, they are, but I think everyone knows what I meant. So, okay, great. So now we move into, I believe we have, before we discuss, well, actually, before we bring the speaker in, we do have a speaker. What I'd like to do is, I have a few friendly amendments that I'd like the board to, if the board is okay, and we just amend this for discussion. We're not saying we're approving this. Just looking at my friendly amendments that have been discussed between Linda and myself, and consider that, and then we bring the speaker in, just in case the speaker has something that deals with something that we've already then dealt with. Does that make sense to everyone? So the changes, if you would turn in your, if you have them printed, to page 3, the third line would be changed from complete to comprehensive knowledge. The fourth line would be changed to comprehensive knowledge. My issue with that was that no one has complete knowledge other than God. So there's not possible. So, and then I think the next one was on the following page, the next page, under preferred qualifications, experience administering and comprehensive knowledge, again, not complete knowledge, of following election-related policies, programs, and the following, we're adding the first bullet point would be a Maryland election law. So we'd be referencing a Maryland election law. And then if you turn the page again, we would change that last line to be ability to acquire and oversee the distribution of state or federal grant funds. That's often done by a grant writer, so I didn't want to. And then 2 add-ons in that section. Number 1 is familiarity with relevant technology. And then another one that would read experience in collaborating with legislators, local governments, local boards of election, and major political parties. And then just one more is that under special requirements, under legal advice, number 1, we would discuss the state administrator of elections is required to be a registered voter in the state of Maryland, and it would end with a period there, because that law actually does not reference the state administrator. Does any board member have a problem with those friendly amendments that were agreed to by Linda and myself?
Mr. Chairman,
Yes.
could you repeat? It came after familiarity with relevant technology. Was
Yes.
it familiarity with collaborating with?
Experience in collaboration with legislators, local government, local boards of election, and major political parties.
Okay.
Any other questions? Is everybody okay? I don't think we're not voting on things yet unless, I don't think we've come to that for the final vote on this. Is everyone okay? Is there anybody that has an objection to those friendly amendments? Okay, so that's going to become the record that we're working with, that we would be talking about, of potentially adjusting more if the board's will is that, and then voting on in the end as what we would use moving forward. We're going to bring the speaker in, but my goal would be hear from our speaker to have a discussion around the 4 corners of the document and what they would read in the document, and making sure if there's any other changes or if the board is okay with that. Then the board would vote on that document. Then we would vote on a timeline and a universe that document is then opened up to for application, and we'd agree to that timeline and the universe that it would go to, And then we'd have a general timeline of when we would conduct interviews and try to make a final decision. Does that make sense to everybody? So then, could we bring in, I think Senator Kagan has asked to address the board. Is she available at this time?
There is.
Great. So sorry to keep you waiting.
All good. Can you all see me and hear me?
We can hear you. We cannot see you. You might have to press the button there to share webcam if it's available to you like it is to
Tech
me.
thing? I don't know that that's a me thing or a you guys thing. There we go. Share my webcam. There we go. All right. Thank you. Thank you, Mr. Chair. Thank you all. I want to start by just doing the thank yous that I think you guys don't hear enough. Thanks to you all for your service on this board. I know it takes a lot of time. Thank you, as always, to our local boards of elections and to everybody who makes democracy happen in Maryland. And thank you for giving me a few minutes today. I attend virtually all your meetings when we're not in session, and I rarely ask to speak, but this is a really big deal. And the new administrator is going to help guide our election process for quite a long time, I would assume. So, and I just want to also thank Justin Williams, who's no longer on the board. And I'm very excited about the talented new people so far that have been appointed. I reviewed fairly carefully the miscellaneous documents and the administrator's report. And Mr. Chairman, some of what you've said has captured some of my concerns. So as always, thank you for your insights and leadership. I objected to the laundry list has to play nicely in the sandbox with 4,000 people. I think it's misleading and somewhat disrespectful. There were also obvious omissions, and I don't think that some of the agencies listed are quite as important as, let's say, the local boards of elections. There was a total omission of the state treasurer, who's a member of the Board of Public Works and would be approving the the procurement in the governor's absence. The lieutenant governor was not included. I think including both of those makes sense. There was nothing about relationships with the press, because we have got to make SBE better at transparency. And for those of you who are not on social media, either in this room or watching or listening, once again, SBE was delayed in complying with the law that requires that meeting agenda and meeting materials are posted at least 48 hours in advance. Now, I understand there were questions for the Attorney General about posting a job description, and I can anticipate that it was about whether it was a personnel matter. That could have been handled, that could have been investigated after the emergency meeting several weeks ago. And so even if that was something that caused a pause button, which I think wasn't needed, I think all the rest of the documents could have and should have been posted. So the MGA, the Maryland General Assembly, it's not just being nice to legislators. I think the new administrator needs to be able to take a call or an email and have a conversation with a legislator who's thinking about legislation, and then reviewing draft legislation and offering feedback about, that's a good idea, but that won't work, and let me tell you why, and explaining it so they don't have to have such a rigorous amendment process or contentious hearings. So there can be collaboration. The other thing that's missing is after legislation is enacted and signed into law, or not signed into law and allowed to become law without the governor's signature. AELR, the Administrative Executive Legislative Review Committee, in terms of drafting and implementing regs. That's another place where legislators could be consulted and collaborated with. So I think I already said the press was totally missing from the list. I was surprised by the heavy emphasis on federal laws, must be super expert at HAVA and all the other, alphabet soup of election legislation. But I think that that's important. I think a new person who didn't have expertise in that could certainly learn it. Personally, I believe that the new administrator needs to have expertise in Maryland law and be familiar with Maryland law. And I am less worried about federal law other than compliance and funding, and something that she or he could pick up. National and international, I want to give a shout out actually to Administrator Limon, who was a representative, has been a representative on national and international groups. And I think that gives us visibility and prestige. I think it is part of our sharing democracy. I know that we often host delegations from other countries. We also have observers that go to other countries and help them with the implementation and conducting of their elections. NIST, the National Institutes of Standards and Technology, which I love to brag is in the heart of my district. Ms. Limon has been connected to them. The EAC, a new agency, fairly new agency. She and I was just appointed to the Election Assistance Commission, and having a presence there, I think, is helpful. And Maryland was a very early adopter of ERIC, the Electronic Registration Information Center. And so all of those, and I know I'm leaving out a million more, the National Association of Secretaries of State, because in most states, it's the Secretary of State who conducts elections and stuff. So any place where we can cross-pollinate, learn best practices from other states, and share some of what we're doing so that we don't have the horror that has happened in recent elections with conspiracy theories and stuff. I think that that's important, and I'd like to suggest that that be added to the job description. Ranked choice voting is not something that everybody loves or that everybody is used to, but there is an expansion of interest and implementation. And more states and localities are using it or trying it. And so compliance with, whether that's a procurement question or implementation or an understanding. Our state comptroller, Bullock Learman, in more than one Board of Public Works meeting has asked SBE about ranked choice voting. There are a number of localities who are using or are thinking about using ranked choice voting. So I think that is something that is worth talking about. Nikki, I think you talked about regs relating to recount. I just want to mention that I did sponsor legislation on recount. It was a good bill. It passed the Senate unanimously, and unfortunately the House decided not to move it, but I'll be bringing that back. And so that's another way of dealing with recount. There were a couple of places on the delegation, and you guys have already spoken to that, so I kind of regretted that I didn't get to speak earlier. But selection of polling places seems like that is not something that should be the sole domain of our administrator. I appreciate the public conversation about by the state board when you're asking, Mr. Chairman, you were always asking, how far is it? And what about mass transit? And is it accessible to people with disabilities? And that conversation, I think, is important to happen publicly. And so I don't love the idea of any administrator sitting in his or her office and just making sole decisions without that transparency and accountability. Same with the chain of custody of ballots. This seems to have that the administrator would make the rules and there would be no accountability, no debate, no public conversation with the LBEs, with our local boards of elections, and they would be told that they had to comply with the rules made by one person. I'm concerned about that. Missing from the job description is any mention of the new administrator, and it is in the law. The new administrator can grant a waiver to the early canvassing that was passed in my bill, Senate Bill 379, that's been signed into law. And rather than may start counting early, since Maryland is the only state in the country that does not allow for early processing of mail-in ballots, now it says, and we did it's hard, you don't want to do a one-size-fits-all, but since someone, especially Anne Arundel County, chose not to start processing their ballots until after Election Day, it was really too late. It caused huge delays in certification. And so the new law says shall start processing 8 days before the start of early voting. And it offered the possibility of a waiver by the state administrator. So if Somerset County has 12 ballots, they shouldn't have to hire people, turn on the video cameras, rent the space and all that. So it will be primarily for small jurisdictions with light use of mail-in ballots, but the new administrator does have that, and that was missing from the job description. Also, something that I didn't see, and if it was in there, I didn't see it. I think one place where SBE has had some challenges, and I'd love for this to be in the job description, is oversight of contractors or vendors. And we know that we had problems and delays with printers, ballots not being sent out early enough, tracking not being done effectively, again, lack of accountability and oversight. And so I think that's important. Mr. Angel, welcome aboard. There's been a lot of turnover with our tech person. And I think, Mr. Chairman, you referenced some facility in tech. I don't think we need a tech guru as our new administrator, but I do think that the new person should at least know the right questions to ask or know whom to trust. Because technology over the years has been a real source of snafus on SBE, whether it's been on the website, whether it's been, anyway, provisional ballots, all that. I know you guys are working on letters to people who have signed up for ongoing vote by, with internet delivered ballots. We had talked about last time putting the word preferred as the mail-in ballot and not the internet delivered ballot, so that we would have reduction or not have people who think it's easy. I bank by mail, I shop by mail, I even date by mail. So of course I want to vote by mail, and they have no idea how hard it's going to be for them, that they're going to need a printer, and the printer is going to have a toner cartridge, and they're going to need a number 10 envelope, and they're going to have to pay for their own postage, which this board just clarified, unless they bring it to the drop-off box. And that's just the beginning of the challenge. That once it arrives at the local board, that they need bipartisan teams to manually duplicate. It's just such a nightmare. And I've been talking about this, and my colleagues understand the challenge. And I think many of them share the concerns that many of you all have. And I think that voter education on this and clear communication as to what a heavy lift this will be for the voter and for the local boards of elections. And I will just say that I'm sure that you all noticed that there was a 50% spike in the number of provisional ballots. And in my opinion, there were at least two obvious explanations. One was the delay in logging in ballots. And so people were wondering whether their ballot had been returned and received, and they were freaking out. And so they showed up at an early voting location or on election day, freaking out. And I want to make sure my vote counts and all that. And so that was one place that I think there needed to be a provisional ballot, and the other was internet delivered ballots. They had no idea how complicated it was, and they gave up. And that's why when they showed up and voted provisionally. So that is an extra burden on our local boards of elections, and that takes more time, more board time, more staff time, and all that at the local levels. And I guess the last thing, and I really do have a lot of notes here, and I've probably omitted some of it, but funding. The state-county collaboration and communication, I think, is a weak spot that we must get better. I have spoken to a few people from a few different local boards, and they did not get early access to these proposed regulations before the board was voting on them. They should see them before, no offense, but before they're posted online, before the board sees it. They should be asked what they think and how implementation would work. And so I would like to see better collaboration, better cooperation, and better communication with our hardworking people at our local boards of elections who just are not getting the support. And now, we were able to fix some of the unfunded mandates that were proposed, but it's a challenge, and I think the state board can do better. So with that, Mr. Chairman, members of the board, I'll pause. I'm sure I've left some stuff out, but I know I've also dumped a lot. And so if I was unclear on anything or you all have any questions, I'm happy to hear them now.
I tried to take some notes on some of your ideas.
I didn't even introduce myself. I'm sorry. I'm Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville and the vice chair of the committee that oversees all election laws, now called Education, Energy, and the Environment. And I always say, and elections. I should have said that at the beginning. Sorry.
Yeah, thank you. So let me thank you for coming, and thank you for your friendship. I think we've developed a great relationship over the last 3 or 4 years. I appreciate our friendship and your friendship to the board. I just want to see if any board members have any questions for Senator Kagan. You must have been clearer than you thought.
Cool. Yay me. Okay.
I have written a few notes that I think are related to our document that we're dealing with today. I think many of the things, points well taken, are general things for moving forward. I think they're very good points. Not sure that they need to be incorporated into a requirements document, but I think they're. I mean, we've talked about them many times. So, yeah. Are there any other questions for Senator Kagan?
Mr. Chair, if you'd like me to try to toss my notes into an email or something so you've got it in front of you, I'm happy to do that. You tell me, or if you've captured the highlights.
I captured some. You're welcome to. You have my email. You're welcome to send an email. I can bring it up on the screen next to me here and see if I missed something. And I'm sure some of the other board members were, had caught some other parts as we go into our discussion. Let me just one more time. Does any board member have any questions? Senator Kagan, thank you for being with us today. We appreciate your time and your support of elections in Maryland to be free and fair. Thank you.
Thank you so much. Take care, y'all. Appreciate you.
Okay. Thank you to Senator Kagan. And let's move on to a discussion. We have some of the friendly amendments. We have a few suggestions that I could pick up there. I think some of Senator Kagan's ideas are more of an all-encompassing how somebody would function, not necessarily what would be working in this document. Does anybody have, after reviewing this document and hearing the testimony of Senator Kagan, does anybody have anything else that they'd like to amend or add to this document? One of the things I might do under knowledge, skills, and abilities, page 3, to Senator Kagan's point, maybe we could add ability to establish and maintain effective working relationships with, but not limited to. So let's add, but not limited to. She had made the recommendation on this long list here of adding the state treasurer, the lieutenant governor. So maybe we could say the governor of Maryland and the lieutenant governor and lieutenant governor of Maryland, AELR, and the press. I think those were good suggestions. Does anybody have a problem with that amendment? Seeing no problem with that.
Mr. Chairman?
Please, yes.
In that vein, perhaps the Board of Public Works, is that a relevant, seems relevant?
Yes, I thought that was in here. Am I wrong?
Did I miss it?
Maybe I read something that was close to it and thought it said it. We can certainly add the Board of Public Works to that if it's not already in there. So I have now the Board of Public Works, the state treasurer, adding lieutenant governor to governor, AELR, and the press.
So if you add the Board of Public Works, would you actually need explicit language saying treasurer, lieutenant governor, comptroller, or governor? Those are the individuals that make up the Board of Public Works. Would that capture everyone? I don't know, Linda. I don't know.
Your thoughts, Linda? I think Linda hit the wrong
I think
button.
she accidentally did a SEV.
She did a SEV. Linda pulled a Sev.
Well, sorry, guys.
That's all right.
Imitation is the most sincere form of flattery.
I love it, man. That's cool.
I think listing the Board of Public Works separately is fine, because we do deal a lot with the staff over there, so,
Okay.
okay. So I got all of that. I got everything.
So we're gonna add Board of Public Works to that, as a separate, because they have a staff, straight treasurer, lieutenant governor, to the governor, AELR and press. And we'll say, but not limited to, because
Right, got it,
heavens knows who else this might be. But yeah.
got it. Okay,
Thank you for that. Any other questions, comments, additions, deletions, corrections?
all right.
Mr. Chairman,
Yes.
if it's appropriate, I just have a question about the order of how the job posting is presented. The examples of work is quite lengthy. I would prefer to see that knowledge, skills, and abilities is first of the categories that's identified on this public document.
Okay.
Then I think at that point, then I would give examples of work. I think it fleshes out the knowledge, skills, and abilities from a logical perspective.
Okay.
And then we could move to qualifications, assuming somebody isn't so incredibly intimidated by the prospect of taking on this job that they would continue on after they've read knowledge, skills, abilities, and what you're going to do daily and with your staff. Then they would move on to qualifications to see if they actually can qualify for the job. So that would just be a recommendation in terms of logical flow of the document.
Does anybody have any problem with that move, switching section 1 to section 2 after the introduction?
No.
Okay. So it is thus done. Thank you, Sky. Any other changes? I've already given my changes. I think I've just added some of Senator Kagan's that from her testimony to honor that. I can just tell you that when I saw this first came over, which is just shortly before it went public, and just did some friendly amendments with our state administrator today, I was blown away. And, you know, it shows just how much work this job has become over the years, and how really, I think the word was superwoman that she must be, you know, because this is a lot. This is really a lot. And so I think we're looking for, and hopefully we get several very special people to apply, so we can choose one. So I would like at this point to entertain a motion to accept, as with the changes we've made through the friendly amendments, the job description and minimum qualifications as presented.
I have a question, Mr. Chairman.
Yes.
On preferred qualifications, did we insert the experience with Maryland election law? Was that your friendly amendment, or was that something? Okay, got it.
Yep.
Okay, got it. Thank you.
Thank you. Is there a motion to approve as now presented after the amendments?
So moved.
It's been moved. Is there a second?
Second.
All those in favor signify by raising your hand. Okay, we have our document. Our next order of business is, obviously we could open this up tomorrow, right? In the next business day. How many days, be it business days or regular days, should we allow for the receiving of applications, or let's say resumes, receiving of resumes? My recommendation would be 15 days. I'm looking to see what you all think. And then in the same token, what universe it would be available to. And my recommendation would be whoever would apply. I mean, I would hope that we could find a qualified person in Maryland. If somebody from Virginia saw this posting and was available and they wanted to apply, we would certainly look at their resume.
Well, I propose that if we can get it posted tomorrow, that we have it closed for the receipt of applications on 2 weeks from tomorrow, which would be the close of business or sometime in the afternoon of May the 19th.
Anybody have a problem with that? That would be 2 full weeks of being open to resume.
Right, and I can tell you that the fact that I'm retiring and that you all are going to be recruiting is very widely known.
Yes.
So we can work with HR as to where to post it, but I would really encourage you guys not to open it up to people out of state, because it's going to take a lot of your time to review all these resumes, and they're just going to have a very difficult time complying with this. Because the other states don't run elections like Maryland does. So we're kind of special here. There's a couple that come close, but I know everybody's time is limited. So I'm just cautioning you on that.
Okay. Thoughts from board members? Let's deal with one thing at a time. Anybody have a problem with the 2-week time?
Dan, I guess I'm gonna make it a legal question. Is that due notice? Is that time enough for due notice for an employment?
Yeah, under personnel law, we can 2 weeks is okay.
Okay, great. Thank you.
Yeah.
Good.
And just to throw this out there, and Dan can certainly comment in with us. I think because of the type of position this is, I'm not sure that a lot of there would be nothing stopping us from voting right this very second on a new administrator and appointing them. Is that not correct, Dan?
That's correct.
Yeah. So I don't think we have many of the normal state requirements, Michael, but that was a great question.
No, I get it. Thank you. Yeah. Good.
So if I may, Bill, if it closes on the 19th, you all want to try to schedule interviews the week of the 22nd?
Yes.
Okay.
I think we need to see how many applications we get, but Sky is shaking her head. Is that not a good week for you to do something? I'd want to do the interviews if we could back to back, so we didn't take people's whole week up. Like if we had narrow it down to 2 or 3 people and interview them back to back.
Mr. Chairman, my only challenge, I'm not leaving the country, which I realize is a rare thing for me to tell you. I actually have a bigger issue, which is that I'm committed to the graduations, the college graduations of my son, and then my niece. My niece is at the University of Maryland. So I have some commitments, definitely on the 23rd of May and definitely on the 24th of May, that it would be virtually impossible for me to participate virtually or in person on the 23rd or the 24th. I can work around schedules on the 25th. And the 26th is really pretty open that Friday. And I could make myself available on Monday, the 22nd, but the 23rd and the 24th would be out of the question because of family commitment and my niece's graduation.
All right, let me ask this question. Do you all want to do these interviews like we're talking now, or do you want to meet and do them in person?
My druthers would be to do them over Zoom, unless board members have a different idea.
Well, it would be a lot easier to do it like in Zoom because then Sev has a long way to go. Well, you all do.
Yeah.
The only one that doesn't is me.
Yeah. So I would
So-
say Zoom, I would say either the afternoon of the 25th or the morning of the 26th. If that works for everybody else, I'm just throwing that out there. We would normally have had a state board meeting, which I'm going to propose not to have one at the end of May, but to move one to June, because there wouldn't be enough new stuff to report on anyway. And we would normally have potentially had a meeting on the 25th in the afternoon, so we could even do interviews then or Friday morning.
I'm going to speak, this is about my own self-interest. I would prefer Friday morning, the 26th. That gives us a week from close of the application process on the 19th, assuming we agree on that. Or if we, I can't remember, I don't even know if we agreed yet. But if we close it on the 19th, that gives us a week. We could interview candidates on the 26th. Personally, that's the one day of the week that's not complicated for moving some things around. I personally think that our Zoom meetings have been very effective as a board. We've worked effectively through the Zoom process in terms of people dealing with, Hollywood Squares format and asking questions and waiting and all of that. And it certainly would allow us to move this process more quickly. And then I would suggest that if the board thought it necessary to do follow-up interviews, and if we thought a follow-up interviews in person would be appropriate and necessary, that we could make that happen in early June. I would think that we could decide that as long as we're transparent about it, if we needed to do that. So my recommendation, my preference for interviewing on the first part of the day on the 26th.
Okay. Michael, do you have a I'm sorry, Seth had his hand up. Yes.
This is more a question of process, but let's say we get 10 resumes. I'm just picking a number out of thin air, and we want to winnow them down to an interviewable size. Is that process subject to open meetings, such that we have to be doing this by a Zoom call or something like that, or can we review the resumes individually and then? Is that an open meeting to talk about what we think about them, or how open is this? Let's put it that way.
About to give me legal advice in a public meeting. But I can discuss that. But the answer summarily is no. This is an administrative matter. You're engaging in an administrative matter, so the Open Meetings Act would not apply to it.
So we could take 10. We can have discussions between ourselves, come to a agreement on 2 or 3 that we wanted to interview them on that Friday.
Yes. Okay, so mark that Friday off, just in
Well,
case.
Mike, does that day work for you? I want to make sure it works for everybody. And Seb,
Yep.
does that day work for you?
Yeah.
Works for me.
Works
Okay.
for you? Well, okay. Okay, so,
I have a question based on what Sky also recommended that the initial interview being over Zoom followed up by an in-person possibly for the final interview, or no? Is that
well, I think that
part of the process, or
that
with
Friday, we felt like we needed in-person interviews, we could then set them up. If we
All right.
felt like we had enough information, we could call a special meeting for that following week. As long as we gave the appropriate time for the special meeting, we could have our meeting with one piece of business, which would be for naming the new director.
Okay, thank you.
My only other question would be what Linda just brought up, and I will defer to what the will of the other board members is. How will if somebody wanted to send in a resume from Virginia, as an example, would we accept that resume, or do they have to be a Maryland resident? Yes, Sev.
So my personal view is not to restrict it. I mean, I think that the criteria are limited enough that either someone may not choose to apply from another state, or if they apply, it might become apparent that they're not qualified, just on a reading over the resume.
Okay.
So, I mean, it creates a little more headache to go through resumes that are perhaps not responsive, but in this day and age, that's what you get.
Okay. Michael, your thoughts on that? You agree with that?
I agree with Sylvia.
Okay. Sky?
Yeah, I agree.
Okay, that's great. That's where I stood. I thought everyone was going to stand in a different place. I'm happy to hear that. So,
Okay.
It can only come from Kent County.
Yeah, so then if we're gonna meet on the 26th to go over the resumes, why don't you check your calendars to see, for example, for calling a special meeting on the 1st of June to announce your selection?
Go to my calendar. Okay. First of June is a Thursday. I can do first 1 June. Can you all do 1 June?
Yes.
Michael?
Yeah, I'm good.
Okay, what time do you want to do it?
Free. Not gonna be a long meeting, you know, we're gonna.
One agenda.
You want to do 1 o'clock or you want to do 2 o'clock? What's work for everybody that day?
I'm preferably later afternoon, 2 or 3, but that's just me.
Okay. I'm wide open that day, so.
Me too.
2 p.m. Let's do 2 p.m. on the 1st.
Okay.
And so we have the 26th. We're going to keep open. We don't know how many interviews we have, and the first June is at 2 p.m. I think we've agreed on a process. Yes, Sky.
Yeah, I think we have one more issue, process-wise.
Okay.
If we close applications on the 19th, and we are going to interview candidates on the 26th, when will we decide who we're interviewing? So it seems as if we will need to communicate.
We will.
And it also seems as if I understood correctly, it doesn't have to be an open meeting because this is an administrative task as well as a personnel issue. But we will need to communicate our preference of who we will be interviewing. And we need to say, if we get these, if they come to us by the 19th, how and when will we get the resumes? How much time will we have to review and collaborate on who we're going to bring in and give those people adequate time to prepare? So those are my questions to get us from the 19th to the 26th.
And I was thinking the same thing.
Yeah.
Very good point.
We can certainly email the applications that afternoon. Let's say why don't we make the closing time 2 o'clock on that Friday?
Okay.
And have the staff get you the applications that were timely received by 2 o'clock. And then where am I? Perhaps on what's your next available hour, Guy, on that following week? Because that would probably be all it takes is a conference call for an hour.
Yeah, that Monday is going to be best. That Tuesday, I'm going to probably be on my way and at College Park for this graduation ceremony.
Okay.
So my Monday is actually best. if that, and I will commit to reviewing whatever needs to be reviewed in and around my son's graduation on Saturday. But being prepared to talk and collaborate by Monday, the 22nd. My only standing meeting that day is at 2:00. I can't move that one. I would open up by 3:00. Would 3:00 make sense, or sometime that morning?
I have a 3:00 that day every Monday.
Okay.
I'm available anytime between that day. I'm available between 11:30 and 2.
Okay.
So would anyone be open to, I hear us trying to make, the weekend is going to be tough for me to make that turnaround. With regards to reviews, or commitment on the 22nd. Is it possible we look at the 26th for offering up our selections and meeting on the 31st, so Wednesday, or interviewing on the 31st, the end of the month, and then making our selections by the 5th of June, which gives us a solid month from today?
All of that actually works for me.
Seems pretty reasonable.
Make that
Okay,
work.
say it again, Michael.
Meeting up on the 26th, well, making our selections by the 26th, open, we have some, if we need that conference call at that time,
Okay.
we're available. That's already set. Then the 31st for the interviews, which is a Wednesday.
Okay.
Following week gives us time for due notice, or give them notice and for preparation for what my colleague Sky has mentioned.
I can make that work.
All right. And
All right.
then the 5th for making our selection.
The special meeting.
The special meeting, yes.
Okay, what time on the 5th, guys?
Well, the 5th is a Monday. Mondays are hard for me.
Okay.
They are? Okay.
Normally, yeah, the week before, that other Monday you just listed, it just so happens my one meeting that's at 1:00 is done to happen. I can have a special meeting, but it would need to be at 12 and I would need to be done at 1. If we were going to do it on the 5th.
Does that work for Sky and Sev and Michael?
And that special meeting that we're proposing for the 5th would be the one that would be relatively limited, where we're making the announcement?
Yeah.
Yeah.
Yes, yes, that would, I can make that work for sure.
Okay, so noon SBE on the 5th. Okay. Anything else?
Special meeting. And I got to put all these in here so I don't book over top of them. So the first, Thursday, the 1st, what is that? What time is that? That is nothing now. So now we're having interviews on the 31st, right?
Correct. That's proposed, yes.
Yeah, I'm fine. I'm fine with that. And then we're meeting to decide who to interview on the 26th.
Exactly.
I think that's a good proposal, Michael. Can we do the 26th at 10 a.m.? I have something to do that day at 12:30.
Yeah, that works for me, 10 a.m. on a Friday.
Yeah.
10 a.m. on the 26th, okay for you, Sky, too? Okay. So 10 a.m. to decide, and then on the 26th. And then the 31st is interviews. And what time did we say our interviews were? We didn't, did we?
We did.
Just
Uh,
mark,
Afternoon.
just mark the day off, and if we only have 2 people, then you just do it in the afternoon.
So my only constraint that 31st is I have something to do from 9 to 10:30. Other than that, I can be free.
Yeah, I do too, so
Okay.
11,
Yeah, just for my purposes on the 31st, ideally, maybe 1:30 or 2, if
Yeah.
we have a limited number of candidates. I have a standing meeting from 11:30 to 1-ish. I can be out of it, but ideally I would make that plus be able to make this.
okay.
So we scheduled like 2 to 5, should be enough time to do hopefully the interviews.
Yes, I think so.
Okay.
All right. What else do we have to do?
So we are in agreement on process, timing, and everything else. Does anybody have anything to add that we've not thought about in the process or that we need to additionally agree to?
Just
Yes.
one thing, at some point, we're gonna have to decide who the person is. We haven't really set a date or time for that, other than the special meeting where we announce it in effect. And I'm wondering if we can just accomplish that.
What I would like to do to address that, Seb, is to take some time with just us, because I think that's closed meeting type, it's administrative functions, that we talk about that directly after the interviews. Does that
Okay,
work?
perfect.
Mhm. Okay, anything else? Okay, so then we are done that. Is there any other old business? Seeing none, we move into, I'm sorry, somebody say something? We move into new business. Any new business? Seeing none, disclosure of campaign contributions. Anybody have any campaign contributions to disclose?
No.
Okay. We move on to the scheduling of the next meeting. So we're calendars back out again, please. I do not believe we need a meeting in 3 weeks. So we will be meeting about all this other stuff. I think, and we will be, obviously, we're hopefully going to be naming a new administrator who would be then working with Linda in a transition on the on June, what was our day? June
22nd?
June 5th, we would have the special meeting,
Oh,
right?
right. Sorry.
So, how long after that would we need? Should we just go to like the 22nd of June to give that new person and the two people enough time to come into that meeting? Does a June 22nd meeting at 2 p.m. work for everybody?
It does not work for me. I'm traveling, family reasons. I need to go to Oklahoma for a mother's knee surgery, which is going to put me out of pocket on the 22nd. I am available on the 29th, though. I'm out till the 28th, but I could be available on the 29th.
I'm on vacation the week of, that includes the 29th, the whole week.
Okay.
Guy, could you call in from Oklahoma?
I fear not on the 22nd. I'm looking at this. I travel on the 21st. The 22nd, my concern, Linda, is that I believe that's the day we bring my mother home from the hospital from the knee surgery. And that could be a kind of crazy.
Yeah.
Yeah.
How about the 23rd, Friday?
The 23rd might not be any better. I would actually recommend perhaps we back it up to Tuesday, the 20th. Is that too crazy?
Michael, Seb?
Okay with me.
I have a 3 o'clock meeting. Is that going to be a lot of business to be conducted that day, or would we be able to have that meeting between like 1 and 3?
Well, we're taking up the restriction to the ballot boxes firearm issue.
I can probably move my 3 o'clock to 4 o'clock. So if I allow 1 to 4, would that be enough? And we did a 1 o'clock.
That works for me, yeah. I'm wide open.
That works for me.
Seems good.
What's the date again, Sky? What date?
Tuesday, June 20th.
Okay, great.
Sounds like 1 to 4, blocking out the 1 to 4 period works for the group, right? Does that work for you, Bill?
Yep. Yeah,
Okay.
I can propose a new time there.
Okay. I appreciate everybody's flexibility, and I'm truly grateful that our process for the selection of a new director is happening earlier in the month of June because it was going to be quite challenging to do this and help with rehab of a knee, a time zone away. So anyway, just my personal gratitude that we're moving as quickly as we are.
All right, well, we'll talk. Is that it? Bill, anything else?
That is everything, I think, since we've scheduled the next meeting. Is there a motion to adjourn?
So moved.
Is there a second?
Second.
All those in favor signify by raising your hand. Thank you for being, everybody, so easy to work with. Appreciate it. Talk to you all soon.
Thank you.